Uh, Hello, everybody. This is Dr. Cole. It is Sunday evening, August 24th, and this will be the Week 2 announcement for Political Science 3753, Constitutional Law, for the Fall 2025 term. Everybody, a few things. We're doing our first discussion tomorrow and Tuesday. That's the 25th and 26th. You were sent a link to a discussion between, an interview actually by Ross Dudat of the New York Times with Jack Goldsmith, who was an official in the Bush administration. And they are discussing the constitutional implications of some of the things Trump has done, which are important. Everybody, we won't spend the whole term talking about Trump, but we will talk about him from time to time. And it's a good way to start off the term with some of the things that are going on now that have important constitutional implications. So hope that will be of interest to you. Take a look at it. During the 48 hours tomorrow and Tuesday, post once and then post again in response to one of your classmates at least once. You may post more than twice if you wish, but post at least 2 times, initially and then in response to one of your classmates, to meet the course requirements for this discussion. And then that will be running Monday and Tuesday, tomorrow as I'm speaking to you, and Tuesday, the 25th and 26th. And there's a link to that in the modules area of the course website. Then later in the week, everybody, we have the quiz. I'm going to leave the quiz open. I just got an announcement out about this for 48 hours instead of 24. Thursday and Friday, the 28th and 29th. It wasn't a good idea to schedule that for the 29th only, because people will be gearing up to get started for Labor Day weekend, I'm sure. So we don't want to butt into your Labor Day weekend if it's not necessary. So you can go ahead and take it Thursday if you wish. It will be open Thursday and Friday. I've already set it to be open for 48 hours. So if you try to take it Thursday and you run into trouble, contact me. There shouldn't be any trouble. I believe it's ready to go for 48 hours on Thursday and Friday, the 28th and 29th. Everybody, let me say a few words about what we have on the syllabus for this week and the material we have for the quiz. On the syllabus for this week is Judicial Review, the class notes for Units 2 and 3, those lecture notes that are up on the course website. Judicial Review, of course, refers to the authority of the Supreme Court to, shall we say, declare something constitutional or not, if they deem it necessary to strike something down as unconstitutional. So they get to say what's constitutional and what's not, so they act as a constitutional court. As I mentioned in the class notes, I believe, we have the idea of the Constitution as higher law. The Constitution trumps everything else. If anything is in conflict with the Constitution prevails. Now, it's often regarded as kind of a problematical doctrine. Not every country has it. There are countries with a written constitution and a Supreme Court that do not provide for judicial review. In other words, their Supreme Court does not act as a constitutional court. For instance, there is a Supreme Court of the United Kingdom. It has been operating for a couple of decades now. They did not always have a Supreme Court. They now have a Supreme Court of the United Kingdom. But that Supreme Court does not have the power of judicial review. It is still the case that, by definition, any act of Parliament is constitutional. Okay? Parliament has the final say over what's considered constitutional or not. And any act of Parliament is constitutional by definition. Okay? On the other hand, in our system, we can have judicial review of an action by a state government or by the federal government, going all the way up to the president, him or herself, Legislation may be judged as to whether it's constitutional or not, okay, either at the state level or acts of the United States Congress. Now, in the class notes, we discuss the first two instances of the Supreme Court declaring all or part of an act of Congress unconstitutional. It took them over 50 years to do it for a second time after they did it the first time in the early 1800s. That was after the Constitution had been in operation for a decade or two. But the first instance of judicial review and invalidating of an act of Congress was Marbury versus Madison, 1803, involving a controversy that had come up regarding the appointment of federal judges after Thomas Jefferson had been elected, but before he was inaugurated. Okay, the election of 1800, highly controversial, partisan feelings were running high and running very raw at this time of American history. In those days, the president was not inaugurated until April. Okay, they fixed that later with a constitutional amendment. It now takes place in January after the November election. So that was the first instance of judicial review. Okay, Jefferson's predecessor had appointed some federal judges before Jefferson himself could be inaugurated, and Jefferson did not want these people to serve on the federal bench. And so this was thrown into the lap of Chief Justice John Marshall, and you will read about what happened. You'll also read in the class notes about the second instance of judicial review, which was the infamous Dred Scott case. Okay, now this came in 1857, I believe it was, and it was an attempt, unsuccessful, on part of the Supreme Court to try to resolve the slavery issue. Okay, the ruling was that Congress could not prohibit slavery in the territories, and Dred Scott could not be considered a free man just for having escaped to free territory. Okay. Chief Justice Taney raised the rhetorical question, is Dred Scott a person or a citizen under the Constitution? Are such people, black people, citizens? We think they are not, he said. Well, it spectacularly failed as an attempt to resolve the slavery issue and the status of African Americans in the United States, black people. And we know the Civil War followed just a couple of years later. Okay. Now, the first two instances of judicial review of an act of Congress then was separated by over half a century. It happens far, far more often these days, but the first two episodes were separated by over 50 years. So you will read about all that, and also some issues that arise with the judicial review, questions that people have about it, and also a number of cases in which the Supreme Court exercised judicial review, but these did not involve acts of Congress. So you read about all that in the class notes for lectures 2 and 3. Now, the quiz on Thursday and Friday, let me say just a few words. Okay, the material, there's one article from the Washington Post for which you have a link. This involves the interaction between President Trump and the Supreme Court and how the Supreme Court might approach it if a case is thrown into its lap, as it may very well be the case in the next few months, questioning whether the President Trump, has abused his constitutional authority with regard to some action that he might have taken. Okay, and the reporter for the Washington Post, Anne Marimo, I believe her name is, attempts to anticipate what the stance will be of the Supreme Court if it should receive a serious challenge from some action that President Trump may have taken. And it's anticipated that this may happen in the next few months or the next year or two. Everyone, this article discusses the Garcia case, the gentleman who was deported to the prison in El Salvador even though he had already been granted protection some years earlier by a federal court. After the article was published, Garcia was released and returned to the United States to face criminal charges. The latest development, I understand, is that the United States government is going to attempt to have him deported to Rwanda in Central Africa. All right, so look at that article by Anne Merimo. Everybody, for the remaining items on the quiz, you'll want to go ahead and take a quick look at the material on the syllabus for after Labor Day, the class notes for lectures 4 and 5. You should be able to go ahead and take the quiz without taking too long of a look at those notes, but it may help you to take a look at them anyway. You're asked to look at the case from the textbook of Ex parte McCardle, which was a post-Civil War case. Now, in lecture 4, we have a discussion of efforts to curb the court. Okay, and there have been efforts on and off through the years to try to limit or strike back at the Supreme Court. President Franklin D. Roosevelt once proposed packing the court, adding justices who he seemed to think would vote his way. Okay. Another way of doing it is simply to appoint new justices as vacancies occur, with views opposed to those of the justices they replace. President Trump has done this with the 3 justices he has appointed. Justices Gorsuch, Kavanaugh, and Barrett. And they have done such things as to go ahead and reverse the 1973 case of Roe versus Wade, which we will be discussing. But the Constitution says, there's language in the Constitution that suggests strongly that Congress can remove certain matters from the Supreme Court's jurisdiction. And they attempted to do this in the Reconstruction era. And this is what is involved in the case of Ex parte McCardle. And you have a very brief excerpt of that in your textbook, and you'll be asked a couple or 2 false items about it on your quiz. Now, the remainder of the quiz has to do with the case of Baker versus Carr. Baker versus Carr is not in your textbook. Okay. A copy of it was attached to the announcement that went out about the quiz, and that file is also up on the course website in the modules area under lecture 1. You should see it, you can download it there. That's taken from a longer 2-volume version of your textbook that we used to use. We now use a slimmed down version of that textbook. But Baker versus Carr involves threshold requirements. That's discussed in lecture 5. There are several requirements that a case has to meet before it passes the threshold of being something that the Supreme Court legitimately can take up. Okay? There has to be a legitimate case or controversy. It can't be a contrived case. The parties bringing the case have to have standing to sue. The case cannot have become moot. In other words, if the court takes the case up and something has happened in the meantime before the court gets the case that has, in effect, resolved the legal issues, then the case cannot go forward. It's been made moot. Okay. Another threshold requirement is that the matter cannot be a political question. Okay. Now, the political question doctrine is one that some people say the Supreme Court uses to duck a case that it really doesn't want to take because it thinks the case may be too big of a hot potato. Okay? And in this case, the court will say, well, no, this is a matter that's for the President and Congress to resolve, not the Supreme Court. Now, so what happened in Baker versus Carr? Baker versus Carr was a reapportionment case. The state of Tennessee had some very small counties, and in some cases it gave those counties the same representation in the legislature as the city of Memphis. So some people in Tennessee complained. They thought they weren't getting fair representation. They thought other areas of the state were getting more representation than they deserved. Now, the court got a case in 1948 about the same issue from Illinois, I believe. and they declined to take the case at that time, or they ruled that it was a political question that they would not review. Okay. By 1962, they reversed themselves, okay, and they laid down the doctrine that we know as one person, one vote. In other words, members of the legislature have to represent a roughly equal number of people. Okay. The great exceptions to that in United States politics are the United States Senate and the Electoral College, which are in the Constitution. Each state has equal representation in the Senate, no matter its population, and that's part of the formula for determining the number of electoral votes in the Electoral College. But everywhere else, we have to observe the rule of one person, one vote, as of Baker versus Carr, 1962. Now, you read the dissenting opinion by Justice Felix Frankfurter, who thought it should have remained a political question. Okay, it had been a political question in 1948. That kind of thing had been considered a political question all along. He wanted to continue to treat it as a political question. But I believe it's Justice Brennan who writes the majority opinion, in which the majority decides they're no longer going to treat it as a political question, and they will go ahead and impose the one person, one vote rule. Now, the thing that makes the decision so interesting is that Justice Brennan lays down several criteria for what is or is not a political question. And that's really what you're going to find that you'll be questioned about in a couple of the items on the quiz, I believe. Okay, so look at your excerpts from Baker versus Carr. If you have trouble downloading those, contact me. But they were attached to a message to you, the message that announced the quiz, and they're up on the course website in the modules area. So download that and look at it. Contact me if you have any trouble with that. You'll need to look at that before you take the quiz. You'll have 10 true-false items, 2 points each. You have 10 minutes to take the quiz. You have 1 minute per item. And that will be available for you Thursday and Friday, the 28th and 29th. For 48 hours, you'll have 10 minutes once you begin the quiz. 10 items, 2 points per quiz. All right, so that is what we're doing this week. We have lectures 2 and 3 on judicial review, and we're looking ahead a little bit to what we have next week. Lectures 4 and 5 on efforts to curb the court and threshold requirements. So I hope all that will be of interest to you. I hope you will take part in the discussion tomorrow and Tuesday. And we will be talking to you once again about a week from now at this time.